Today I'm going to be talking to you about discovery. There's two main forms of discovery, written and oral depositions. There are three types of written discovery: request for admissions, request for production, and interrogatories. Requests for admissions are a series of factual statements that the other side would serve upon you. And you need to answer those by either admitting them, denying them, or saying that you don't have enough information to answer the question. Those are usually pretty straightforward. You do have an opportunity to object if the other side is asking you for a legal conclusion. The next form of written discovery are interrogatories, and those are a series of questions about your case. You would need to answer those questions to the best of your ability with the assistance of your attorney, and your answers do need to be under oath. The other form of written discovery are requests for production. That is a series of requests for certain documents that you have that are relevant to your case. Of course, you need to retain all the documents that you have that have to do with your claims or the other side's defenses. Document is a very broad and general term. It includes everything from text messages, answering machine messages, emails, faxes, draft documents, agreements, notes, pretty much anything you can think of. So you want to gather all of your documents and send them to your attorney. Your attorney will help you decide what is responsive to the question and whether there are any documents that do need to be held back for purposes of being subject to attorney-client privilege or the work product privilege. Those documents would usually be put on a privilege log. Now, of course, as a plaintiff, while you have to answer discovery, you can also serve discovery. So your attorney would draft requests for production, requests for admissions, and interrogatories and serve them on the other side. They would have to answer those just like you did. The other form of discovery is an oral deposition. When you are deposed, you will usually go to either your attorney's office or a court reporter's office, and the opposing attorney will have an opportunity to ask you a series of questions with a court reporter taking down everything that you say. Your attorney would be present and would have an opportunity to object to the questions, but the ability to object is usually pretty limited, and usually it can only be to the form of the question. That would be so that your attorney can preserve the objection if your testimony is later used at a hearing or at trial. Depositions can go for a few hours, but you have an ability to take a break. You should tell your attorney if you need to take a break, but you typically do have to answer the question that's pending before you take any break. Your attorney can also do a deposition of the other side's corporate representative. That party will have to designate someone who can talk about certain topics that are important to your case. And it'll be the same scenario with a court reporter present and your attorney getting to ask all of the questions that have to do with your case that will help you prove your case. If you have any questions about bringing a consumer lawsuit in the state of Florida, you can give me a call at 813-982-3663. I look forward to speaking to you about your case. Thanks so much.